For all the latest news, latest updates happening around town, yes, consider subscribing and also hitting the notification button. And many thanks to you wherever you're listening in and watching in from. Yes, President Yoweri Museveni has told the Supreme Court that he has no problem with National Unity Platform leader Robert Kyagulanyi, also known as Bobi Wine, for withdrawing his 2021 election petition. Kyagulanyi on Wednesday filed a formal application to the court seeking to withdraw his petition challenging Museveni's victory after citing unfairness by the court. However, in the response through an affidavit by Oscar Kihika, the NRM party director in charge of legal affairs, Museveni, who is the first respondent, says he has no issue with Kyagulanyi changing his mind and asking to withdraw the petition. Yes, the first respondent, who is Museveni, does not oppose the application for withdrawal of the petition. And I make the above averments to set the record straight with regard to averments by the applicant in support of his application. Kihika, who swore an affidavit as the person coordinating the team handling Museveni's case, that is what he had to say. In his affidavit, Jackson Kafunzi, the Deputy Attorney General, also shared the same sentiments on Kyagulanyi's application to withdraw his 2021 poll petition. Not happy with Bobi Wine. However, the affidavit, Kihika says he does not agree with the reasons fronted by who? By Bobi Wine, as having forced him to seek to withdraw the petition. It is not true, as alleged by Robert Kyagulanyi, that in previous election petitions, parties were given free rein to produce evidence throughout the trial. I know in the presidential election petition in 2016, CAT gave definite deadlines for the filing of evidence, Kihika said. He says that the court gave ample time to Kyagulanyi to file their evidence, contrary to what he avers in the application for withdrawal. The application within the allowed time by court only filed 7 copies of one bound volume of affidavits containing 50 affidavits and subsequently filed 3 affidavits named supplementary affidavits. The content of the affidavits by the applicant alleging abduction of witnesses is a false claim which is irrelevant to the current application, as the evidence to be relied upon by the petition was already before this court at the time of filing the application. Kihika also says that some of the national ID documents and particulars of the witnesses whose signatures were found to be forged were attached to the respective affidavits in court through application by Kyagulanyi. Museveni's lawyers say that Kyagulanyi conducted himself in a way that didn't respect to the Supreme Court. It didn't give respect to the Supreme Court, noting that it would be wrong for him to turn around to accuse the same court out of bias. The applicant conducted himself with total lack of discipline and contempt of this court when he held a press conference to announce his decision to withdraw the petition, falsely claiming that his decision was biased on the recusal of 3 justices of this honorable court to recuse them, yet no recusal application had been made by the applicant. The applicant in the same press conference made disparaging remarks on the justices of this honorable court. Wherever the lawyers made no mention of costs incurred in the case, the law stipulates that a petitioner will be liable to costs if he or she decides to withdraw a presidential election petition. If a petition is withdrawn, the petitioner shall be liable to pay the costs of the respondent, and that is the Presidential Election Act 2005, and that is what it stipulates. Yes, many thanks to you wherever you've been watching and listening in from. Yes, Progen Media for all the latest news, latest updates happening around town. Yes, consider subscribing and also hitting that notification button.